Hey everybody! For those of you that I haven't met yet, who I hopefully it's not a lot of you, I'm Steph. I'm Russ's wife, and I'm the CFO and Chief Legal Counsel for the Dirty Buffalo. A little bit about me: I actually practiced law for about 10 years before I started working full time for the Dirty Buffalo. A little bit of that was in employment law, and I also taught a couple courses over at ODU for business students that included employment law concepts. So I am fairly knowledgeable on this stuff. I wanted to give you guys an overview just to give you basic information. But if you have any questions after watching this course, or if anything comes up in the course of your employment with the Dirty Buffalo where you have questions about employment law issues, please feel free to reach out to me. You guys should all have my email, have my cell phone number, so I am happy to answer questions anytime. But let's go ahead and get started so you can have at least a basic introduction to what you might be encountering in your time as a manager with us. So the first thing to remember is the basic rule in Virginia is this is an at-will employment state. That means that you can essentially fire somebody for any reason, as long as that reason is not illegal under some independently existing state or federal law. Another way of saying that is that our handbook is not a contract. It actually explicitly states that. And we can separate from an employee for any reason or no reason whatsoever. So you don't have to wait for somebody to be late a certain number of times, or no call, no show a certain number of times if they're a poor performer or if they're just not the right fit. It's actually better to separate from them as early on in the employment relationship as possible, because unemployment does not kick in until 30 days of employment. So the one thing that we could be liable for if you terminate somebody without any reason is unemployment. But as long as that's within the first 30 days, then unemployment is not available. So why do restaurants get sued if you can fire somebody for any reason? Well, there's a couple different reasons. There's a couple different laws that come up, and I want to touch on some of them. The first is if somebody gets paid incorrectly, they don't get overtime, or they don't get minimum wage, or some other violation of wage and hour law. That's one of the main reasons that a lot of restaurants get sued. So we'll talk about that. We'll talk about federal and state discrimination laws, anti-discrimination laws. So while you can terminate somebody for no reason, you certainly can't terminate them for racially based motivations or discriminatory based motivations, like discriminating against them on the basis of their gender or disability or religion. We'll talk about the ways those things come up. Obviously, it's not always a blatant disregard for somebody's just protected status. It can be unintentional as well. So we'll talk about how those unintentional violations could come up. Workers' comp is not actually a way that employers get sued. It is a statutory scheme that replaces negligence lawsuits. So what that means is that if an employee gets injured while they were at work, then workers' comp provides them a certain amount of compensation regardless of who's at fault. So we will talk about what our managers need to do to ensure that we comply with workers' comp law. Unemployment, as I mentioned, is something that is available to employees after 30 days of employment with us. It's, again, not exactly a lawsuit. It's a claim that employees file with a state agency. And if they are approved, then that's not money that we essentially pay out of pocket. It's mandatory insurance that we have, and our insurance rates will fluctuate depending on how many claims we have to pay out. So it is best to try to avoid employees getting approved for unemployment claims. Other laws that you might have heard of during the course of your employment as a manager include OSHA, FMLA, NLRA, and privacy issues. We're going to touch on a couple of those, but we're not going to be able to get into all of them in a lot of detail. Okay, so the first thing you need to know is that wages in Virginia are currently at $11 an hour is the minimum wage. That will go up to $12 an hour on the January 1st of 2023, and then up again to $13.50 in 2025 and to $15 in 2026. Now that may change. That's the law as it states today, but there are certain proposals to change that. So just keep that in mind. We'll keep you informed of any changes to minimum wage law. Tipped workers can still make $2.13 an hour in Virginia, but the minimum wage just means that after they collect their tips, they have to get up to $11 an hour. If they don't make up to $11 an hour in any pay period, after taking into account tips, then we at the Dirty Buffalo have to make up that amount. It's called make up tips. That's why it's super important for our employees to report cash tips if possible, because when we report cash tips in payroll, then we're actually taking into account all of the tips they receive, not just the credit card tips. So they, that the full amount of what they are receiving is getting put into whether or not the decision of whether or not they're making $11 an hour. Overtime for tipped workers is currently $7.63 an hour. The way you calculate overtime for tipped workers is that you multiply the regular minimum wage by time and a half, and then you subtract the difference between minimum wage and the tip wage, which is $8.87, and then you multiply your total by the number of overtime hours. So that's how we got to the $7.63 an hour, if anybody asked about that. Another important rule is that men and women must receive equal pay for similar tasks. That's called the Equal Pay Act. So if you hire, for example, a man and a woman to both be shake cooks, and they both have similar experience, and they're both going to be training only in that position, then you can't pay the man more than you're paying the woman. They have to receive the same amount of pay. Now, you can always vary that after time based on seniority, if they're with the company longer, merit, if they're a better performer, or other factors not related to gender. But it should always be documented to make sure that it's clear that if there is a difference in pay between a man and a woman, this is the reason why, performance or whatever. We have suggested wage charts, which you'll see as part of your manager training for both the front of the house and the back of the house. We update them regularly. So we ask that our managers, you do have discretion to determine how much to pay somebody, but we ask you that you keep it within the ranges that we suggest. If you want to go outside the range, and the ranges are quite big, then just contact the corporate office and we can, if you want approval for that, we can go over that at that time. We certainly encourage raises and promotions. We prefer to promote from in-house than to hire managers outside. We think that's the best way to grow our company, is to reward people who are great performers who start with us and then work their way up. However, if you are going to promote somebody or give them a raise, we ask that you do that in the context of a performance review, because then there is the documentation we need to show that this person is getting more money than other people because they are performing really well, or because they've been with us for X amount of time. So we just ask that you document that, and we do have a performance review form that you can use twice a year to do performance evaluations. Okay, another tricky area for wage and hour law is tip pools. Got to keep in mind that the federal government says that tips are property of servers and bartenders who receive them. Tip pooling isn't exactly illegal under the Federal Fair Labor Standards Act. That's FSLA I was referring to, but it does say that you can't include employees who do not customarily and regularly receive tips. So what does that mean? The way that's been interpreted is that it is okay to include servers, bartenders, hosts, and busters in a tip pool. It's not exactly clear whether you can include food runners or barbacks, but most restaurants at this point have been assuming that they're permissible. It is certainly not okay, according to federal law, for back of house employees to be included in tip outs. So tip pools can only include front of the house workers. Side work. So there's been a bunch of restaurants, the Darden companies, Applebee's, who's the other one? One of those barbecue restaurants Smokey Bones, that have gotten sued in pretty public lawsuits over the last couple of years because they were having some of their tipped workers do work where they weren't generating tips. So tipped employees who make less than $7.25 an hour base, and actually, I'm sorry, that hasn't been updated, less than $11 an hour base, because that's minimum wage, cannot spend more than 20% of their time doing side work. So that includes cleaning, setting, bussing tables, making coffee, taking inventory. So if you have employees that are making less than that base amount, then you want to make sure that they're spending 80% of their time doing tipped work. That's also important for if you have training days or cleaning days, anything like that. You have to make sure that your front of house workers are clocking in under training pay, so they get at least minimum wage and they're not making their $2.13 an hour. The other way that this side work claim comes up is if people are doing work off the clock, even if you haven't told them to, they can come back and sue for compensation for that off the clock work. So it's very clear that employees need to clock in and clock out for all their hours. And you cannot require them, and in fact, you should tell them explicitly that they should not be doing things if they're not clocked in. And this is for all hourly workers, all people that are not on salary with us. So any cleaning, any cut work, even checking 7 shifts messages or doing their onboarding on Paycor, all of that has to be paid for while they're clocked in at the restaurant. Uniforms, this comes up because you actually can't make employees pay for uniforms in Virginia until they are receiving at least minimum wage. So because we have people who start with us and are making training pay of only $11 an hour, we can't deduct the cost of the uniform out of their first check because that would put them below minimum wage. So that's why we have that uniform deduction agreement that all the employees have to sign as part of their Paycor onboarding, which says that if they do not stay with us for at least 90 days, then the deduction for those uniforms will come out of their last check. So if they stay for us for more than 3 months, it's free. They don't have to pay for it. But because we have a lot of high turnover in our industry, we do want to redeem and get that money back for people who don't last 90 days or more. So make sure you're communicating that to human resources whenever somebody is terminated. If they've received a uniform and it hasn't been 90 days, we need to know that so we could take it out of their last paycheck. Never make your employees pay for cash shortages at the end of the night out of their tips. If they make a mistake and the kitchen has to comp something or make food, do not make them pay for it. That's illegal. And we can't ever make them, or we can't deduct from their paychecks for misplaced or broken items. So that's why it's really important if like a manager is terminated, that we have to get their keys back or we have to get their computers back, because if we don't, then we have to change the locks or buy a new computer. We can't get that money back out of their last paycheck. Break periods. Okay, so this is a little tricky situation. Federal law actually says that break periods are not required. You do not have to give your employees a break unless they're under 16, in which case Virginia law provides that they do have to get a break. But if you do choose to provide a break under federal law, you have to pay for it if it's under 30 minutes long. So if you give people a 15-minute break or 20-minute break, it has to be on the clock. And they can't clock out for that. If you are going to require your employee to clock out, then for it to be considered a break under federal law, that employee has to be able to completely stop doing all work. So they can't be multitasking, and they have to be free to leave the building. You can't keep them on the premises. So to avoid all of these obstacles with break law, we just put a break policy into place that says employees are entitled to this many breaks based on how long they work, and they're going to be paid. We do not make them clock in or clock out because we don't want to run afoul of this law. We have this break policy for a reason. Please do not discourage our employees from taking breaks or pressure them to perform duties while they're on their breaks. Abide by the break policy and give them that time off during their shift. Okay, so That was wage and hour law. Now we're going to move on to discrimination law, which really all comes from Title VII of the 1964 Civil Rights Act. So this law is a federal law that prohibits employers from discriminating on the basis of race, color, religion, gender, including pregnancy, and national origin. It is also the basis for all of the sexual harassment suits that you see going around. Okay, discrimination can occur not just on the job, but during a lot of the job process. So it can occur during recruiting. It can happen during interviewing. It can happen during, so that means that even people who have never been employed by us can sue us for discrimination. It can happen during hiring. It can happen when you're assigning tasks and duties to people, if you're being discriminatory in who has to do what, if you're discriminatory in your performance evaluations or your pay decisions, or who gets promoted, who gets demoted, and then in termination as well. There's also a thing called a hostile work environment claim that you might have heard of. It's usually brought up in sexual harassment cases, but it applies to any discriminatory conduct that creates a work environment that is so hostile to the employee that they basically feel like they have no choice but to leave. It's called constructive termination. All right, here's a couple ways that a discrimination lawsuit could come up. These are called disparate treatment cases because it is where the employer is treating some employees differently than others based on some of those protected characteristics that I just described. So, for example, if a male applicant claims that the Dirty Buffalo hired a less qualified female employee for the host position, they might argue that, you know, the Dirty Buffalo has this image that they have to have female hosts, and that's why they didn't hire me, because I am a male. A female employee might argue that she was passed over for a promotion to sous chef in favor of a male cook. Again, might make the argument that male cooks are traditionally more often promoted to sous chef positions, and she was passed over even though she had the same qualifications as another person, a male that worked for us. Another argument is if a black line cook claims that he was paid less than a white line cook, even though they have the same level of experience. So again, when you're making those decisions regarding pay, make it clear in your documentation why you're making those decisions, because if there are discrepancies in pay, we don't want anybody to feel like it's for discriminatory reasons. If a religious employee claims she was terminated because of her unavailability on Sundays. So we do have the requirement in our employee handbook that during football season, we require employees to have open availability on Sundays. However, we make exceptions for that if an employee has a bona fide religious reason for not being able to have open availability that day. So if an employee states to you that they go to church every Sunday, or they have some other reason that's religious in nature for not being able to work that day, it's important to honor that request. Another thing that could come up is a Hispanic employee might claim he was terminated because the kitchen manager didn't like his accent. And it doesn't have to be as clear cut and dry as the KM saying, hey, I don't like your accent. It could be repeated instances in the kitchen where people keep saying, what, I can't understand you. That could be a discriminatory type claim. So how does an employer protect itself from all of these types of discrimination lawsuits? Well, the biggest way is through documentation, because the burden in any lawsuit is going to be on the employer to show it had what's called a legitimate business reason for its employment decision. So the more real-time paperwork we can create, the more evidence we will have if a claim is ever made. So this doesn't mean you should come up with bogus reasons for all your employment decisions. You should document your actual reasons for your employment decisions. But it does mean that you should complete all the required paperwork to maintain a complete employment file. So you'll get an employee file checklist that you'll see as part of your manager training. And that means all of that paperwork needs to be included in the file because of these legal reasons. It also means that you should have a witness present during all disciplinary sessions. So it should be the manager making the termination decision, and then he should bring in a witness when that termination or corrective action is being taken. And the other thing that often comes up is, what if an employee says, I'm not going to sign that right up. I refuse to sign that. I don't agree with it. That's okay. The law actually says that even if the employee won't sign the write up, it could still be considered valid documentary evidence. So if an employee refuses to sign it, just say, okay, I'm going to put it in your file and I'm going to notate that you refuse to sign. All right, let's talk about sexual harassment. So 79% of women and 71% of men have experienced some form of sexual harassment from coworkers while working in the service industry. So the service industry is one of the worst industries in terms of sexual harassment being in place. It's not the worst industry in terms of lawsuits. So what that's showing is that people aren't necessarily reporting it as much as they should, even though they're experiencing it. There are two major categories of sexual harassment that are prohibited by Title VII. The first one is called quid pro quo, or this for that. And that's when some aspect of the employee's job is made contingent or conditional upon the employee's sexual activity. Another one is the hostile work environment claim that I previously mentioned. And that's when there's some kind of sexual talk or innuendo that's so pervasive that a hostile work environment is created for that employee and they feel like they have no choice but to leave. All right, important things to remember about Title VII and sexual harassment is that the harassers and the victims may be either gender. So that means you can have a male who harasses a male who harasses a female who harasses a male, or a female who harasses a female. It does not matter what the gender is. And also, it's not just involving employees. Guests can sexually harass our employees. Vendors can sexually harass our employees. Other visitors can as well. So all of those situations are areas where the Dirty Buffalo could be liable if we don't take some kind of corrective action after we receive notice that this stuff is going on. At the Dirty Buffalo, we have a zero tolerance harassment policy. What that essentially means is that if there is a claim that an employee makes against either another employee or their supervisor or a guest or a vendor, where they made even a single comment or a single instance that made them feel uncomfortable and led them to the conclusion that they couldn't work with that person anymore, or they couldn't work with us anymore. And if we investigate that claim and it turns out to be true, then that's grounds for disciplinary action. And that disciplinary action could include termination. So that's what our zero tolerance harassment policy means. It's important to communicate that at the onset of the employment relationship so that everybody knows that not only is reporting encouraged, but we take a very firm stance that this is not tolerated in our organization. So let's talk about the legal rule and then how that's different from our rule. So the legal rule is that a true hostile work environment claim has to meet certain legal criteria. And that means that an environment is hostile when there's unwelcome conduct or harassment based on race, sex, pregnancy, religion, national origin, age, disability, or genetics. And that harassment is continued and long-lasting. Under the law, the conduct also has to be severe enough that the environment becomes intimidating, offensive, or abusive to the employee. To establish a hostile work environment claim, the employee has to be able to show that the words or actions of the coworker or supervisor made it impossible for them to do their job effectively. So that's a pretty high burden, actually, for getting compensation under the law for sexual harassment or harassment on any one of those other grounds. Based on those statistics that I gave you a couple slides ago on how prevalent this type of harassment is in the restaurant industry, the Dirty Buffalo didn't feel like this was a strong enough stance to prevent that within our restaurants. So that's why we adopted the zero tolerance harassment policy. And as long as we communicate that to our employees at the onset of employment, this is perfectly legal for us to have a stricter standard. So again, that rule is that even a single instance of unwelcome conduct, which is based on sex, pregnancy, religion, national origin, age, disability, or genetics, if that single instance makes it difficult for an employee to work effectively, and that's confirmed after we do an investigation, then that's grounds for termination. I want to give you a couple of examples of what sexual harassment can look like, because there's a lot of assumptions, or at least back in the day, I think it's gotten better over the years, but about 10 years ago, I would say there's a lot of assumptions that sexual harassment had to be somebody explicitly talking about sexual activity or physically touching an employee for it to be a violation that is considered a viable legal claim. And that's just not true. Sexual harassment can be a lot of things. It could be telling stories that involve explicit sexual content or sexual jokes. It could be making sexist, offensive, or crude sexual comments. It can be attempting to have unwanted conversations about sex or sexual situations with an employee. It could be requests for sexual favors, or it could be unwelcome advances. The other thing to keep in mind is because of that quid pro quo sexual harassment claim, that other type of claim under Title VII, if the harasser is a supervisor and the person being harassed is an employee, that can be a claim for which the Dirty Buffalo is strictly liable. What that essentially means is that even if we didn't know about it, or even if we didn't have a chance to investigate it, we would be liable to that employee for that sexual harassment claim. So that's why we have that fraternization policy in our employee handbook, where we prohibit our supervisors from fraternizing with their employees, because this is how a situation could come up. Say you have even a perfectly consensual relationship between a service manager, for example, and a bartender. And they're going out, they're having a great time, everything's going great. And then somebody else comes along and they are no longer in a happy relationship. So where that goes south, then you might have the bartender very upset with the service manager and making a claim of that it was non-consensual and that it was sexual harassment. That is a situation for which the Dirty Buffalo potentially could be strictly liable. So for that reason, we do not allow our managers to fraternize with employees. And honestly, it's bad business judgment to begin with. So keep in mind of that fraternization policy as well. Things to keep in mind as a manager. Most people are afraid to report instances of harassment. It is just not a comfortable thing for people to do. They're embarrassed. They have a fear that they're going to get in trouble, or they might just accept it as part of the industry because it might be something that they've been enduring for the past 5-10 years or however long they've been working in the service industry. So as managers, you guys have a responsibility to make employees feel comfortable enough to report these types of instances to us. And if you see them happening, because that's most often the case, is that these things are going on right in front of our managers' faces or other employees' faces, then step in and use bystander intervention to make it clear to the person that's doing this offensive conduct that it's not okay, it's not tolerated. And to ensure that the employee who is the victim knows that you've got their back. Also, make sure you immediately report anything you see or hear. You're not going to get in trouble. The employee's not going to get into trouble. We're going to do the investigation for you, so it's really not going to be any other work on your part. So we've got that human resources at thedirtybuffalo.com email for that reason. You can shoot us an email anytime and just let us know this was brought to my attention and it needs to be investigated, and we'll take over from there. Keep in mind, we have customers that are harassers too, and this happens in the service industry a lot. If a server complains, for example, that they're made uncomfortable by a harassing customer, then the manager has a responsibility to move the employee off that table. and be prepared to inform the customer that servers should be respected at all times. If the customers don't comply, then you absolutely have discretion to ask them to leave. And then also just keep in mind that you don't want that server to feel like they're being punished. So assign them to other tables to ensure that they have the opportunity to make up those tips. All right, let's talk about age discrimination very briefly. So the Age Discrimination in Employment Act prohibits age-based discrimination against employees or job applicants who are at least 40 years old, but it doesn't prohibit minimum age requirements. So what that means is the ADEA is designed to protect people from being discriminated against because they're elderly or because they're growing older. So particularly in the service industry where we tend to have a lot of younger employees, it's important for us to consider equally those applicants that we get that are over 40 because they need to receive the same consideration as our younger employees do for the positions they're applying for. Just like with Title VII, discrimination can occur in all aspects of the employment relationship, not just hiring. It can be termination, it can be promotions, it can be the work environment, et cetera. Minimum wages for work. This is an issue that comes up a lot. So who can you hire? How old do they have to be to work for us? Well, I think everybody knows at a minimum that you have to be 18 to serve alcohol. That means that our servers and our well, I'll get to delivery drivers in a second, but our servers have to be at least 18. You have to be 21 to bartend. You actually have to also be 21 to deliver to-go cocktails. So that's a new rule that came out after COVID. We hired delivery drivers for a little while. Right now we're using third-party delivery services. So this is not something we have to worry about, but in case it comes up again, they do have to be 21. 16 to 17-year-olds can be hosts. They can be carryout specialists. They can be food runners, or they can be dishwashers. 16 to 17-year-olds or anybody under the age of 18 cannot use quote unquote hazardous equipment. That means they can't use a slicer, they can't use a fryer, they can't use gas range. So they can't be a prep cook, can't be a line cook, can't be a fry cook. However, if they are 16 to 17, there's no restriction on the amount of hours they can work. So they can work any day of the week for as long as you need them, as long as they're compensated for overtime. We can also hire 14 to 15-year-olds with a valid work permit. If they are within this age range, then they cannot work more than 3 hours on a school night or 18 hours over the course of a school week. They also have to be out every night by 7 p.m. During the summer, when school's not in session, then they are not allowed to work more than 8 hours in a day or 40 hours in a week, and you have to have them out by 9 p.m. Americans with Disabilities Act. This prohibits employers from disqualifying a job applicant or an employee with a disability if the employee can, with reasonable accommodation, perform the essential functions of the job. And a lot of those words are highlighted because those are the key factors that have to be proven in a case. So in plain English, that means that we have to make reasonable accommodations for people with disabilities unless those accommodations would create some kind of undue hardship on the restaurant. What is considered a disability? Well, a disability is some physical or mental impairment that substantially limits one or more of an individual's major life activities. Or it could be a record of such impairment. So if they have a doctor's note saying they have a disability, or it could be one's being regarded as having such an impairment. So if they're in a wheelchair, even if they don't have a quote unquote disability, if they're in a wheelchair, a lot of people would consider them to have one. You may not ask about disabilities before making a job offer. Okay, so what to do about the ADA? If an employee or an applicant mentions a condition that might limit or impair his or her ability to perform a certain task of their job, you should be thinking, could this possibly be construed as a disability? The next thing you should ask yourself, is there anything I can do to accommodate the employee's request? And then the next question to ask is, would it pose an undue burden on the restaurant to make that accommodation? So I know that's a lot of legal jargon. So I'm going to give you a couple of examples that come straight from the ADA website. So one of the examples involving restaurants is Phoebe has an intellectual disability, which significantly limits her ability to think and learn. She would like to apply for a position as a dishwasher at our restaurant. However, the application process is computerized, which is what we have. Phoebe can't use the computer and asked to apply for the job in person using a paper application. If we don't grant that request, then that could be construed as a violation of the ADA. Another example, Remy works as a cashier and a host, escorting diners to their seats at one of our restaurants. Because of a disabling degenerative disease, Remy can no longer perform the function of escorting diners to their seats. He needs to sit down at work. There are no vacancies at the restaurant where Remy currently works. However, there is a vacant cashier position or carryout position at one of our other restaurants. Remy is already trained to be a carryout specialist. In that circumstance, it would not pose an undue burden, according to the law, on the Dirty Buffalo to switch him to a carryout position at the other restaurant. So if you have a situation like that, it actually often comes up with our employees during pregnancy, where they have to sit down at work, then we should make every attempt to honor that request by seeing what other positions we might have available, even if they're at other restaurants. One more example, let's say, and again, this is straight from the website. Let's say Adelio, who is blind and uses a service animal, applies to work as a cashier at our restaurant, carryout specialist. Adelio explains that the dog can sit near the cash register area while Adelio works. According to the law, we may not automatically reject Adelio because he uses a service animal. We have to allow Adelio to keep the dog near the cash register unless we can prove that doing so would impose a significant difficulty or expense or a significant risk of substantial harm. So you think about those circumstances, that's actually pretty hard to prove unless it's a violent animal, that this would be pose a significant risk of substantial harm. So some of these are a little counterintuitive. That's why I wanted to make sure that I gave you guys these examples. Okay, next one, Family Medical Leave Act. So this applies when an employee requests leave, a leave of absence for their own health condition, which is commonly childbirth, or to care for a family member. It's not paid leave. In the United States, there's no federal law for paid leave, but it does mean that we have to keep their job open for 12 weeks. So we cannot replace them, or if we do replace them, it has to be a temporary worker. So their job is still available to them when they come back. We have a notice that we have to provide to an employee about whether or not they're eligible. So anytime that an employee asks you for medical leave or leave to care for a family member, please contact Human Resources to get that form, because we have to give that to them under federal law, saying whether or not they're eligible. To be eligible, they have to have worked for us for at least 12 months, and they have to have worked at least 1,250 hours over those past 12 months. There are special rules for service members. So service members can actually qualify under this act for any qualifying exigency arising out of the fact that the employee's spouse, son, daughter, or parent is a military member on covered active duty. And in circumstances involving service members, they actually can take up to 26 weeks of FMLA leave in a single 12-month period. And finally, we're going to talk about workers' comp really quickly. So as I mentioned previously, workers' comp is a statutory scheme under Virginia law that entitles employees to a certain compensation for any time that they are injured at the workplace. So if an employee is ever, and we have insurance for this, and we have notification requirements, we have to give the insurance company notice as soon as an employee is injured. So if an employee is ever injured at the restaurant, manager on duty must immediately document the injury and the circumstances so we can notify our insurance carrier. There are penalties that we have to pay for late notice. So it is extremely important that that is communicated as soon as it happens. If it's a serious injury, and the employee has to go to the doctor, then you have the ability to tell the employee that they have to go see a doctor before they return to work. Our preferred facilities are patient first or Velocity Urgent Care. And we actually have to display notices in the restaurant that can provide a number for employees to call to put in a workers' comp claim. All right, that's actually all I have for today. So again, if you have any questions regarding any of the topics that were discussed in this video, or if anything comes up employment law related, please feel free to contact me.